When you think about legal rules, I mean, there's usually an expectation of precision, right? It feels um, almost like engineering.
Right, like a math equation.
Exactly.
Yeah.
You run a red light, the camera catches your license plate, the law says you pay a fine, and the judge just, points at the photo. It's binary. You did it or you didn't.
Yeah, and we really gravitate toward that kind of clarity in the law. I mean, it is comforting when things can be neatly categorized and just cleanly resolved based on visible, indisputable facts.
But the moment you step into the world of federal civil procedure,
Yeah.
specifically the rules of jurisdiction, that clean binary system just gets incredibly murky.
Oh, absolutely. It's totally opaque.
Right. And we are looking at a jurisdictional landscape that is just full of hidden trap doors. And if you are listening to this right now, chances are you are the learner. You are right in the thick of prepping for the multi-state bar examination, the MBE.
And civil procedure can feel like, well, like navigating a minefield blindfolded.
Yeah, let's put it lightly. So our mission for today's deep dive is to essentially remove that blindfold and completely crack the code of 28 U.S.C. Section 1332.
And once you understand the underlying historical logic of Section 1332, you really can navigate the exam's trickiest traps with a lot of confidence.
So the core topic here is diversity jurisdiction and the rules of citizenship.
Right. The whole purpose of a diversity jurisdiction, going all the way back to the framing of the judicial system, is basically to give out-of-state parties access to a neutral federal forum for state law civil cases.
Which, I mean, that makes sense fundamentally, right? If I'm a citizen of Texas and I'm suing someone in Oklahoma over, say, a messy contract dispute.
You might be a little worried.
Exactly. I might legitimately worry that an Oklahoma state court judge or jury is going to favor the hometown kid. So the federal court steps in to act as that neutral ground.
But the problem there is that federal courts are courts of limited jurisdiction. They do not have inherent power to just hear every dispute simply because it's, important or expensive or complex.
Right.
They only possess the authority that the Constitution and Congress specifically grant them. Because of that, the statute, Section 1332, has to be satisfied down to the exact letter. Courts guard those jurisdictional doors very, very closely.
And they're basically two main pillars to get through those doors. First, you need complete diversity of citizenship. And second, you need an amount in controversy that exceeds $75,000 exclusive of interest and costs.
Which is a whole other beast.
Oh, totally. Figuring out exactly what counts toward that $75,000 threshold, like aggregating claims or valuing equitable relief, that is a massive topic that gets its own deep dive later. Today is strictly about mastering that first pillar. Complete diversity.
Right. So complete diversity is a standard that requires absolute separation. It means no plaintiff may share state citizenship with any defendant.
Not even one.
Not even one. It is a much stricter standard than minimal diversity, which you do see in some specialized contexts. But for ordinary diversity jurisdiction, there must be zero citizenship overlap across the litigation line. Every single plaintiff must be diverse from every single defendant.
So if I'm sitting in Texas and I decide to sue a defendant who is a citizen of Oklahoma, complete diversity exists. Texas on one side, Oklahoma on the other. It's a clean break.
Exactly. It's a perfect baseline. Complete diversity is satisfied. But if we change the facts just slightly to introduce a multi-party scenario, the fragility of the rule really shows.
Oh yeah, it breaks fast.
Right. So that same Texas plaintiff sues the Oklahoma defendant, but then decides to also name a second defendant who happens to be a citizen of Texas.
And the entire case just gets thrown out of federal court.
It is completely destroyed by that one match. Texas is on both sides of the V. The fact that the plaintiff is completely diverse from the Oklahoma defendant provides no protection whatsoever. Yeah, that single overlap across the opposing sides completely strips the federal court of diversity jurisdiction over the entire action.
Okay, let's unpack this a bit. Because to achieve complete diversity, you first have to know how to measure a single person's citizenship.
Which sounds easy.
It sounds like the simplest thing in the world. It should just be where you live. But where you live is actually one of the most dangerous MBE traps waiting for test takers.
Oh, 100%. The trap lies in the legal distinction between residence and domicile. For an individual human being, citizenship equals domicile.
Okay.
And domicile requires two very specific concurrent elements. You need physical presence in a state and the intent to remain there indefinitely.
So if I'm getting this right, residence is like a hotel or a college dorm where you are staying right now. But domicile is where your mail, your dog, and your long-term plans permanently reside.
That's a great way to put it.
Because, I mean, you can have a summer house in Maine, a work apartment in New York, and a condo in Florida. You reside in all of them, but you only have one domicile at a time, right?
That is the exact distinction courts make. You can have multiple residences simultaneously, but you can only ever have one true domicile.
I have to push back on this, though, because how can a court actually determine a person's invisible intent?
It's tricky.
Right. I could physically stand in my Florida condo and declare to anyone listening, I intend to stay here forever. Even if my entire life, my business, and my family are all still up in New York. How does a judge measure what's actually inside someone's head?
Well, what's fascinating here is that the courts don't just take your word for it. Self-serving declarations of intent carry very little weight.
Oh, really?
Yeah, you cannot just utter magic words to create a domicile if the reality of your life points somewhere else. Courts look at a pretty comprehensive checklist of real-world conduct to determine where your true intent lies.
They're essentially looking for the paper trail of your life to prove where your center of gravity actually is.
Exactly. They look at where you are registered to vote, where you pay state taxes, what state issued your driver's license.
All the boring paperwork.
Yep, all of it. Where your vehicles are registered, where you maintain your primary bank accounts. They even look at where your family actually lives, where your children attend school, and where you maintain your strongest professional and social ties. It is a highly factual, holistic look at your life to find your true home base.
Let's apply this to a specific scenario from our material. Take a student who grew up in California. Their family is in California, their driver's license is from California. But they go to college in Massachusetts.
Okay, classic scenario.
They live in a dorm or an off-campus apartment in Boston for 4 entire years. While they are in school, they are indisputably physically present in Massachusetts. But they intend to return to California after graduation.
So in that scenario, their domicile remains California. They are a resident of Massachusetts during those 4 years, absolutely, but they lack that concurrent intent to remain there indefinitely.
Right, because they plan to leave.
Exactly. So for the purpose of diversity jurisdiction, they are treated strictly as a citizen of California.
And this is exactly where the exam writers set the snare for you. If a fact pattern explicitly states a party is a resident of Florida, that does not conclusively establish Florida citizenship.
No, it does not.
The word resident is a giant red flag. You have to look past the label for the facts that establish domicile, that specific combination of presence and intent.
Never, ever assume residence equals citizenship on an exam. The moment you see the word resident, you should immediately be scanning the rest of the question for clues about where that person actually intends to stay indefinitely.
Here's where it gets really interesting, though. Because domicile requires intent, and human intent changes constantly. People get new jobs, they retire to warmer climates, they move for family.
Sure, people are mobile.
Because people
Yeah.
are constantly in motion, when exactly do we take the snapshot to measure this complete diversity? We sort of need a stopwatch to freeze the action.
And the stopwatch clicks exactly at the time the lawsuit is filed. This is universally known as the time of filing rule.
Time of filing.
Right. Diversity is measured at that exact precise moment. Whatever happens before or after is generally irrelevant to establishing the court's initial jurisdiction.
Okay, let's test that rigidity. Say a Texas plaintiff sues a Texas defendant. At the moment the complaint is filed with the clerk, there's a match. Texas versus Texas. Complete diversity does not exist.
Right, it fails.
But a month after the lawsuit is filed, the defendant realizes the jurisdictional issue, packs their bags, and moves permanently to Oklahoma. They establish a brand new domicile, register to vote, get an Oklahoma license. Does that retroactive move fix the jurisdiction and save the federal case?
No, it doesn't. And if we connect this to the bigger picture, we have to go back to the fundamental nature of federal courts.
Yes.
You cannot retroactively manufacture jurisdiction.
Because of the snapshot.
Exactly. The snapshot taken at the exact moment of filing lacked complete diversity. Therefore, the federal court lacked the constitutional and statutory power to hear the case on day one. That later move to Oklahoma does not cure the original defect. The case belongs in state court.
So the snapshot is absolutely final. I assume that works in reverse to protect the court's power, too.
It does.
What if a Texas plaintiff sues an Oklahoma defendant? Perfect, complete diversity at the moment of filing. But a month later, the Oklahoma defendant moves to Texas and establishes a domicile right next door to the plaintiff. Does that destroy the jurisdiction?
It does not destroy it. The snapshot was valid when taken. Complete diversity existed on day one, so the federal court validly took jurisdiction over the dispute.
Wow. Okay.
Yeah, a later move that destroys diversity will not strip the court of its power to hear the case. The time of filing rule provides necessary stability. Otherwise, a defendant could intentionally torpedo a federal case just by moving to the plaintiff's home state right in the middle of litigation.
That makes total sense. Actually, I was going to ask if there's ever any mechanism to fix a broken snapshot, or if you just have to start all over from scratch in state court.
Well, there is one very narrow procedural exception. If a case is filed and lacks complete diversity strictly because of a specific non-diverse party, and that party is legally dispensable, meaning the core of the dispute can be fairly resolved without them, the court might allow that party to be dropped from the lawsuit to cure the jurisdictional defect.
Just kick them out to save the case.
Basically, yes. But on an exam, the time of filing snapshot is your absolute bedrock rule.
Okay, got it. So we've established how to measure individuals who can physically pack up their lives and move across state lines. But measuring a person is one thing. Measuring a sprawling corporate entity is another.
Oh, entirely different.
Because businesses exist in multiple states simultaneously. They don't have a driver's license or a voting record. How do we take a snapshot of a company's citizenship?
This introduces what we call the entity trap. The most crucial analytical step here is distinguishing carefully between a traditional corporation and an unincorporated association, like an LLC.
They aren't treated the same.
No, they are treated entirely differently under the law. Let's look at corporations first. A corporation is granted dual citizenship by statute. It is a citizen of every state or foreign state where it is incorporated, PLUS, the state or foreign state where it has its principal place of business.
Dual citizenship. Okay, the state of incorporation is usually straightforward. That is just where they file their official corporate charter, which is, very often Delaware.
Right, the paperwork state.
But what actually defines the principal place of business for a company that might have retail stores or factories in all 50 states?
So the Supreme Court established the nerve center test to answer that exact question. The principal place of business is the single nerve center. This is the real headquarters, where the highest level officers actually direct, control, and coordinate the corporation's overall activities.
So it can't just be a nominal headquarters on paper. Like, a company cannot just rent a P.O. box in Nevada, declare it their headquarters for tax or jurisdictional reasons, while the CEO and all the executive vice presidents are sitting in a boardroom in California pulling all the actual strings.
Right. The courts will look right past the P.O. box. The nerve center is where the actual executive direction happens. So if a corporation is incorporated in Delaware, but its executive nerve center is in California, that corporation brings both of those citizenships to the table.
At the exact same time.
Exactly. It is a citizen of both Delaware and California simultaneously.
Which means if a plaintiff from Delaware sues them, complete diversity is destroyed. And if a plaintiff from California sues them, complete diversity is also destroyed.
That is the hard rule for corporations. But the landscape changes dramatically when we look at unincorporated associations. We are talking about limited liability companies, general partnerships, limited partnerships, and even labor unions. This is where test takers routinely lose points.
Wait, so what does this all mean for an LLC? Because if an LLC operates in 10 states and has members living in 10 different states, does it actually take on 10 different citizenships? That seems like a massive, almost unfair disadvantage compared to a traditional corporation that only ever gets 2.
It does seem unfair, but the historical logic here traces back to how the law views these entities. A corporation is a distinct legal fiction, an artificial person created by the state. An unincorporated association, however, has traditionally been viewed simply as an aggregate of the individuals who make it up.
A collection of people.
Right. Because of that historical view, unincorporated associations do not get the corporate nerve center rule. For an LLC or a partnership, the entity takes on the citizenship of all of its members. And for a partnership, that includes every single general and limited partner.
Let's walk through the exact mechanics of the LLC example from the material because it really highlights how brutal this rule is.
Let's do it.
Okay, you have a Texas plaintiff. They sue a defendant LLC. The LLC was officially formed in Delaware, and its sprawling corporate-style headquarters is in New York. But the LLC has 3 members. One is domiciled in Oklahoma, one in Florida, and one in Texas. What happens to the jurisdiction?
Complete diversity fails. The federal court cannot hear the case.
Even though it was formed in Delaware and headquartered in New York, which are completely diverse from the Texas plaintiff.
None of that matters for an LLC. Where it was formed is irrelevant. Where its nerve center is located is totally irrelevant. You only look at the members.
That is wild.
It is. Because one of those three members is domiciled in Texas, the LLC itself is infected, so to speak, with Texas citizenship. Since the plaintiff is also from Texas, you have Texas on both sides of the V. The case is jurisdictionally dead on arrival.
That is such a critical distinction to internalize. Corporations equal incorporation plus nerve center. LLCs equal every single member. If you mix those up on the exam, you will get the wrong answer every single time. Okay, so we've covered individuals acting for themselves, and we've mapped out the different business entities. But what happens when a party isn't acting for themselves, or when they don't neatly fit onto the map of the United States?
That brings us to the proxies and the nomads. Let's look at the proxies first, legal representatives. We are talking about the executors of a decedent's estate, or the legal guardian acting on behalf of an infant or an incompetent person.
Okay.
In these specific representative cases, the statutory rule dictates that the citizenship of the represented person controls, not the personal citizenship of the representative.
So essentially, the executor is just wearing a legal mat of the deceased person for the sake of the lawsuit.
Yeah.
And I imagine the court does this to stop clever lawyers from just browsing out-of-state executors to manufacture diversity out of thin air.
Yes, it is entirely about preventing jurisdictional manipulation. Let's say a lifelong citizen of Ohio passes away. Their family wants to file a state law claim in federal court against an Ohio defendant.
Which normally they couldn't do.
Right. If the rule allowed it, they could simply hire a professional executor who happens to be domiciled in Illinois to artificially create diversity. Illinois versus Ohio.
But the court sees the Ohio mask the executor is wearing.
Exactly. For diversity purposes, that Illinois executor is treated strictly as an Ohio citizen because the decedent was an Ohio citizen. Ohio versus Ohio means no complete diversity.
That shuts that down quickly.
It does. Now, it is worth noting that class actions have specialized rules, like under the Class Action Fairness Act, where you only look at the named class representatives. But for general diversity questions, focus on this strict representative rule for estates and guardianships.
That cleanly prevents people from gaming the system. But what about the nomads? Because the material details a really subtle trap involving U.S. citizens living abroad.
Oh, this one is fascinating. This raises an important question. What actually is the statutory text that grants this jurisdiction? Section 1332 says jurisdiction exists between citizens of different states, or between citizens of a state and citizens or subjects of a foreign state. You have to fit into one of those specific buckets.
State versus state or state versus foreign country.
Right. Now imagine a United States citizen who permanently moves to Paris. They buy a home. They intend to stay there indefinitely. They are unquestionably domiciled in France. Are they a citizen of a U.S. state?
No, because their domicile, their physical presence and intent is no longer in any U.S. state.
Exactly. Are they a citizen or subject of a foreign state?
Well, no, they just moved there. They are still a U.S. citizen operating on an American passport. They haven't become a French citizen.
So they are neither. They have effectively fallen into a jurisdictional black hole. Because they are not a citizen of any U.S. state and they are not a foreign citizen, they do not fit into the statutory categories of Section 1332.
That is incredible.
If a U.S. citizen domiciled abroad is a party on either side of the lawsuit, they completely destroy diversity jurisdiction.
So if a U.S. expat living in France tries to sue a citizen of Texas in federal court, the judge has to throw it out. Not because they share a state citizenship, but because the expat doesn't have a qualifying citizenship to begin with.
That is the nomad trap. And while we are analyzing foreign elements, you also need to be extremely careful with lawful permanent residents.
So someone who lives here legally, but hasn't naturalized as a U.S. citizen yet.
Right. The trap here is assuming that permanent residents are automatically treated as foreign citizens for all diversity purposes. You have to read the domicile facts very carefully.
Because of where they live.
Exactly. The statute specifically prevents diversity if a lawful permanent resident is domiciled in the exact same state as an opposing U.S. citizen. So if a French citizen who is a permanent resident of Florida sues a U.S. citizen who is also domiciled in Florida, diversity fails. The shared state domicile overrides their foreign citizenship status.
Because Florida is on both sides of the V. The mechanical layers to this are just incredible. But I think we have the tools to build a foolproof strategy. When you are looking at an MBE question, you don't just read it passively. You look at the board. You isolate every single plaintiff and every single defendant.
And you lock in their status at the exact time of filing. For individuals, you dig past the word resident to find their true domicile based on presence and intent.
For corporations, you map out both their state of incorporation and the actual executive nerve center. For LLCs and partnerships, you dig into the citizenship of every single member or partner, ignoring where the entity was formed.
You look past the executor to the deceased person they represent. You watch out for the U.S. expat who doesn't fit on the board at all. And finally, you cross-reference every plaintiff against every defendant looking for a single match.
Diversity jurisdiction really does start and end with identifying citizenship, party by party. You cannot guess, you cannot rely on loose labels, and one single match ruins the whole puzzle.
The federal courts guard their doors closely, and they expect you to know exactly who is asking to come inside.
They really do. As we wrap up this deep dive, I want to leave you, the listener, with a final thought to mull over before your next practice exam. Think about the bizarre paradox of this entire system.
How do you mean?
Well, the federal system is so incredibly rigid when it comes to preventing people from manufacturing jurisdiction, right? They force LLCs to count every single member across the country. They force an executor to wear the decedent's legal mask just to stop clever lawyers from hiring out-of-state proxies.
Right, it's very strict.
It is an elaborate, heavily fortified wall designed to rigidly protect the boundaries of federal power. And yet, despite all those complex defenses, a U.S. citizen who simply decides to retire to Germany accidentally short-circuits the entire federal court's power just by existing in a statutory blind spot.
It is quite the paradox. A fortress of rigid rules completely undone by a simple move abroad.
It highlights just how strictly the courts interpret their own limited power. They won't stretch the text of the statute, even an inch, to save a case. It is a fascinating structural quirk and a perfect reminder of why you have to read the rules exactly as they are written. Keep that paradox in mind when you're tackling those citizenship questions. Good luck with the prep, and we will catch you on the next deep dive.